Welcome back to the courtroom, folks. And buckle up, because this case is not your average bond hearing. We've got Shane Clark, accused of violent threats, a terrified victim, and a prosecutor who's demanding the court take real action before it's too late. But here's the twist. Despite all those threats and chilling text messages, the defendant was released on a personal bond. Yeah, you heard that right. No cash, no bail. So today, the prosecution's fighting back, and the judge is about to decide whether Clark walks free or gets locked down.
I believe the defendant was arraigned on May 1st and was given a personal cognizance bond, and this was against people's request for a $25,000 cash surety with a GPS tether. People have serious concerns in this case for particularly the victim's safety, with nothing more than a PR bond in place. In this case, the victim's defendant had an argument. He called her a fat bitch and pulled out a knife. He was held the knife to her throat while yelling in her face, "If you interrupt me again, I'll snuff you and kill you right here." He was so close to her face while he was yelling this that spit was hitting her face. He said right before he left the car, he stated once to her that once he gets his disability check, he's going to buy a .22 caliber gun and shoot her in the head. She's in fear for her life and her mother's. She also received a text, which I believe, and for it to be read into its entirety, and it says, "You better for real stay out of my way. Don't text me unless I text you. You take my child's phone away again, I'll dismember your whole body to pieces. No cap. I'm overplaying with you. I will literally just kill you and get my life right. Free healthcare. My daughter's safe with your mom. Keep fucking playing. CUNT. I promise you don't know how real I am." And I have just extreme concerns given that he held a knife to her throat and is threatening on multiple occasions in this one case to kill her. And after the arraignment, the victim did send us a screenshot of a text, I believe from March 28th, which was before this case occurred, from the defendant, in which the message said, "Call the cops, I don't give a fuck, I'll murder your ass the day I get out." And that was before this case. So I have concerns given that she has finally reached out to police about this defendant's behavior, what could happen to her, given that he's out on a PR bond for this, in which he threatened her life twice. Oh, probably more than twice, I believe. 3 times.
Response.
Your Honor, I'll be requesting that the court maintain the PR bond with GPS tether. Mr. Clark is currently on a GPS tether. It was addressed that day that one issue, as noted in the prosecution's bond motion, was a concern about a cell phone. Mr. Clark does have a cell phone, which he is using now for his GPS tether that's currently on his ankle. The concern was a lack of data, not him not having that device. He now has data on that cell phone. He received that. He had until Monday today, the 5th, to obtain that tether device. However, he did so within 24 hours. He was released from jail on May 1st, 2025 at 3:57 p.m. I received a call from Mr. Washington, one of the tether agents from Community Corrections at 1:22. So within that small time frame, he was able to obtain data for his cell phone and go to Community Corrections to get a tether. Mr. Clark has also been in contact with social workers, one of whom drove him here today, who are assisting him greatly in obtaining housing, which he is now on a list for those who are chronically unhoused, and hopefully should be able to obtain housing soon, and to be put on a second list as housing vouchers are now being opened again. They've also been assisting him with other matters, such as his health. He is currently suffering from liver failure and has an appointment scheduled for May 9th and one for June 14th, which at that time, his social worker will be also assisting him in getting a hotel. As noted in the emergency bond order by the prosecution, Mr. Clark has successfully been dismissed from probation in the past, showing that he can follow court orders. He does have the money to pay for the tether. He does have transport for the court. And the complaining witness, while acknowledging that this is a serious case, does reside over 30 minutes away by driving. Mr. Clark does currently rely on his social worker for transportation. Again, those, as mentioned, anything mentioned by the prosecution, it's still allegations at this point. We are not here to litigate any of the allegations here today. We are here to address bond. I do not believe there is any change in circumstances that have occurred since his arraignment that I handled last week that would warrant any changing of his bond. He is currently on a GPS tether. The court can know where he is at all times. And I believe that this bond is sufficient to protect community safety and fight.
Is the GPS just location tracking?
It's occasion trafficking and includes an exclusion zone for the complaining witness's address. So he would not be able to get within a quarter mile of that address.
Where's the defendant residing at this point?
He is currently residing at a camp as he awaits housing.
At a camp?
Yes, he has a campsite that he resides at.
Where's the campsite?
Oh, the Miller and Maple Park and Ride, sir.
And there it is, one of the most surprising moments in this hearing. Clark isn't living at a house or even a shelter. He's camping out near Maple Park. That's not just unusual, it complicates everything for the court. How do you enforce a GPS tether when the defendant doesn't have a permanent address? Where's the exclusion zone if he's literally in the woods? The defense argues he's trying to rebuild his life and follow court orders. But for a judge, that kind of instability raises major red flags about supervision and safety. What's your take? Does homelessness make him more sympathetic or more unpredictable?
Well, just so that we're clear, this isn't by the Maple Miller Park and Ride?
Yes, sir.
So this isn't a commercial campsite. This is just a place that you have.
I'm holding out until I can get help, sir.
Yes, so she is part of the Pathway Housing Program. I do have a letter from that social worker here if you'd like that, Your Honor. And Ms. Montaigne, the coordinator for that program, is in the courtroom at this time.
Pardon?
Ms. Montaigne, the coordinator for that program, is also in the courtroom. She is the one who helped Mr. Clark get arrived at the court today.
The The only address I have is the South Line address. Is that a correct
I
statement?
believe so, Your Honor.
How did the defendant and the alleged victim in this case, how did they know each other?
Your Honor, I believe they have been in an on and off relationship since January of 2018, and they have one child together, and that his previous DV from 2021 was with this same victim.
The child who resides with mom, is that?
With her mother,
Her mother.
the victim's mother.
It's the magistrate did order no contact with the victim's mother as well on the day of the event.
I see that, but so does the victim reside with the mother also?
I believe so, because it says the child attends school in South Line as well, so I believe so.
How old's the child?
Born in 2019.
About 6. 6. The defendant's not working.
The defendant is working on getting a disability at this time due to some of his medical concerns.
Then how is he paying for the tether?
He does have some, he has shared with me, he does have some money for the tether.
Panhandle and pick up cans and do work for a lady that I know whenever she needs it. She hires me for yard work.
So how long have you been residing at the campsite that you set up?
Since last year, sir.
Are you the only one out there at that site?
Yes, sir.
Let me see, council and chambers, court standing. Back on in the record on the Clark matter. I've had an opportunity to speak with counsel in chambers, and what the court is going to do at this time, and Mr. Clark, I need you to understand what I'm going to do. I'm going to leave you on the GPS tether. I'm not going to increase any monetary bond that might incarcerate you. Okay, you understand that, sir?
Sure.
And then what I'm going to do is I'm going to, at this moment, increase the exclusion zone on your tether for all of South Lyon. Okay?
I understand.
And then, and I don't want it put on the record, but I'm also going to add a provision of no contact with the minor child. You understand that, sir?
Yes, sir.
All right. And then once the other part to this is that may change where I get more information regarding the victim, the alleged victim and her travels. And then I may be expanding that exclusion zone. Follow me?
Yes, sir.
All right. So that's what I'll do at this time. I think I'm going to need a new order. So I'll prepare a community corrections order with the exclusion zone is all of South Lyon. And then Ms. Zenda, if you could provide to the clerks the name, the minor child's name.
So here's how it ends. Judge keeps Clark on his GPS tether, but expands the exclusion zone to cover all of South Lyon and adds a strict no-contact order with his child. No jail, no new bond, but a clear warning that one misstep could land him back behind bars. It's a fascinating balance between compassion and caution. The court recognizing his personal struggles while protecting the victim at all costs. Cases like this show how complex domestic threat hearings can be. Every decision carries real-world consequences. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns right here. Today's courtroom is filled with tension and consequences. A young woman, Miss Johnson, stands before the judge for sentencing, but she's already on thin ice. Missed tests, ignored assessments, and mounting frustration from the bench are about to collide. Will her father's desperate plea save her from jail? Or is the judge out of patience? Stick around. This one takes a sharp turn you won't see coming.
Possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes, and they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at St. Joe's. She does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
And Teresa Claire on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over and she wasn't scheduled to do a test today, so she did not test. She did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing.
Why?
Why what?
Why'd you miss a test? I mean, I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yeah.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
Oh, they do so much. I mean, I didn't send you the last time. I'll re-refer to defendant Tuvon Swartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening and assessment, the only thing that I can really sentence you to is the maximum time. And I don't want
The
to.
paper,
What?
the paper,
What
with all
paper?
the lists on it. What is Von Schwartz?
That's for your alcohol screening and assessment.
You can almost feel the judge's frustration here. He's not trying to be harsh. He's trying to make her understand the stakes. Von Schwartz isn't some mysterious punishment. It's the place she was supposed to get her alcohol assessment done. But her confusion, delays, and forgetfulness show the court she might not be taking this seriously. And when a judge feels someone isn't learning, that's when leniency disappears.
There's somebody I'm supposed to go to. What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out. My office also sent an email to her on June 5th, which gave her the packet and the information for the alcohol assessment in addition to the information to complete the victim's impact.
Need to pay a $75 referral fee. Do you have that?
No.
Adjourner sentenced at August 28, 2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that. I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for the bond violation. Defendant remanded. Yes, go. Is that Dad?
Yes, Your Honor.
Get her back. Dad, hang on one second. Go ahead, take her back. Come on up to the, can you come up to the phone? What's your name, sir?
Tony Johnson.
Okay. Can you help try to get her through the,
Yes, I will definitely make sure that she does it. She lives with her mom, so I don't kind of know the things that kind of goes on. So I'm just coming to support, and I just was hoping that you didn't take her to jail because
I know.
she need this job so bad.
I know. And I trust me, I did not want to. I just, Miss Clara, can you give to Dad the Von Swartz information and the victim's impact information so that he has it, so that I get where he is, so that he knows what she has to do.
Yes, Your
So
Honor. I do know, I heard him in the hallway, really getting after her for not doing things. So I think that he will.
Well, I don't.
In the end, it wasn't the lawyer who saved Miss Johnson. It was her father. His calm promise to take responsibility gave the judge just enough faith to hold off on a harsher sentence. But make no mistake, this was her final warning. In cases like this, one missed test or skipped assessment can be the difference between freedom and jail time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts below, and subscribe for more real courtroom breakdowns, where every decision could change a life. Welcome back to the courtroom, where things are about to get heated. Today, we're watching Mr. Cummings face the music after violating his probation. Again. This is a man who's been given chance after chance, but can't seem to stay out of trouble. The judge already warned him once, and now he's back after running from the police. His attorney is begging for mercy, but with new charges, unpaid fines, and broken promises, this hearing might be his last shot at freedom. So buckle up, because this courtroom is about to explode with tension.
Yes, the court ordered him to do that, and the bench warrant was issued. He has been, since picked up on the warrant, has been in custody. At this time, Mr. Cummings is still in the same situation he was on June 12th. He still has a balance of $2,255. He's made no payments to the court. He failed to complete the level 2 driver rehab program, failed to complete 100 hours of community service. He has another new pending case since June 12th, an alleged R&O, date of offense, July 22nd, 2024. He does have a PCC on August 1st in that case. So the court is also aware Mr. Cummings does have another pending case on 14B. It is a domestic violence case. He goes for sentencing on that on Monday. That is not a violation of this case. It happened prior to his sentencing. However, he also, in that case, has a bond violation as he violated the no contact order in that case. That will be addressed at their sentencing hearing as well. Mr. Cummings, in this case, Your Honor, it started as a felony case. We did get him sentenced in it. However, prior to all of that, getting him to sentencing in January, he had multiple failure to appears before this court. He continues not to follow court order. Given that he has demonstrated that he does do probation is recommending that he serve 365 days in jail, credit for 85 days that he served to date, to serve the balance, that he complete the in-jail MRT program with the court to consider early release upon his completion with that, and that he be discharged from probation without improvement with and waiving remaining terms, accepting his financial obligations.
You know, I did have a lengthy conversation with Mr. Cummings yesterday. He does admit that he messed up on probation.
So he admits to these violations.
Yes, except for the pending cases for obvious reasons. He wants to ask the judge for mercy in this situation. He would like for his probation to be reinstated. He said he is willing to comply with probation and get done what he needs to do. However, he does want to take responsibility for not doing what he needs to do over the past couple months. So when I asked him what's been going on, he kind of gave me a litany of things. He cares for his 5-year-old son, who is going to kindergarten in the fall. He also has a baby on the way. His partner to the 14th, but really the baby can come any day. Those two things, as well as his job, he's working Amazon night shift 40 hours a week, essentially distracted him from taking care of what he needs to do on this probation. He does live with his mother and his partner, as well as his children, so he does have a support system. He says he can make payments. He is working full-time.
Now here's where things get emotional. Mr. Cummings is asking for mercy, talking about his kids, his pregnant partner, and his night shift job at Amazon. It's a heartfelt plea, but the court doesn't run on emotions. It runs on accountability. Having responsibilities doesn't erase your legal duties. Many defendants use family as a reason to stay free, but judges see through excuses fast. So here's the real question. Does being a father make him more deserving of leniency? Or does it make his behavior even more disappointing?
And he does have some savings that he can put a pretty substantial payment toward his fines and costs. He said his mom can come up and pay $1,000 before he even is released from jail. He mentioned to me that he has been successful in other probations and thinks he can be successful here if the court is willing to give him another chance.
How did he get picked up on this warrant?
The police came to your apartment for an unrelated matter. And Mr. Cummings would like to make a statement he wrote down.
Did you have something, Ms. Polera, before he?
Say, when the police did arrive at the apartment, it was for an unrelated matter, and I believe that he ran, and that's where the new RNO case came from.
Go ahead.
I want to start like this and say I do got a 4-year-old about to be 5 in October, about to start school this fall. I got a daughter due any day this month. I was working a night shift at Amazon, 40 hours a week, 10 hours and 30 minutes a day. I was laying down on my side, didn't look at it as a punishment, but I looked at it as an opportunity to do better and be better and get my life together. I can't have warrants and actually be responsible for my son and get to school every day or even to a bus. Please don't punish me or revoke my probation. I think y'all can actually help me do and be better. I signed up for Michigan Reenters to try to get back in school and see what college is like. Even though it seemed like I haven't been trying, that's something me and my probation officer spoke about. I can and I'm willing to do extra classes like MRT free and on probation. I'll pay to start my driving class before I'm even released, if considered. And if you can take thought that I'm on probation for being a victim in a car accident I was in or at fault for, I went to the hospital with bad injuries, just as everybody else. Like, please, Your Honor, I've been getting dealt a bad hand. And I always have just try to be the best I can and resolve every issue the best way possible. Honestly, I'm not the best, but also not the worst. Like, please, Your Honor, I beg you, please, can I have one more chance to show y'all I actually had a bump in the road and I had to get over it, please. If you see me again, you can revoke my probation, give me a year or anything. Like, I really do and truly apologize for the confusion and decisions I left y'all left you, my probation officer, to ponder with. But I really have just been working, trying to be there for my son and the mother of my child that's currently pregnant. Like, please don't punish me yet, but give me one more chance. Like, I'm actually a full-time father and my son stays with me. I can't imagine just leaving my son out the blue like this. He missed me as we speak and think I'm on vacation. I'm going to be a full-time dad to my daughter too, that's due. This is the first time you see me for a reinstatement and the last time if possible. I'd do anything to be there when my daughter is born and put my name on the birth certificate. I watched my son go off to start his first day of school. Your Honor, I plead and please, I'd do anything, even if it was double my community service, double my restitution, and add extra classes. I'd do it and complete it all. If you can, please consider everything I said and give me a chance. It would be the biggest and best blessing. I know I haven't paid yet, but I thought I had time to. I had kids, house, and life things to take care of. I haven't started my driver class because I was supposed to start it a month after being released, but I didn't have a job or was told that I had to pay to start it after being released. I know I haven't started my community service, but I checked in the places that let me serve the community legally to get this out the way. If I can, please have one more chance to show y'all. You wouldn't regret it, I promise. But that's all I have to say and ask of, Your Honor, sincerely.
Cummings, here's my problem. On September 13th, you were set, well, before that, I think I took your plea. You were supposed to appear for sentencing. Actually, I didn't take your plea. Looks like it was taken by another judge. But anyway, you were supposed to appear for sentencing. You were supposed to do a PSI with the probation department. This was back in September 2023. And you don't do any of that. And I have to issue a bench warrant. Somehow or another, it looks like that may have gotten set aside. in January, and then I adjourned your sentencing January 9th. We had to somehow or another find you from September to January. And then on January 9th of 2024, I adjourned your sentencing. It was adjourned by.
Now pay attention. This is the turning point. The judge is retracing every date, every missed deadline, every failure. From January to June, nothing was done. That level of non-compliance pushes any judge to the edge. By this point, it's no longer about compassion. It's about protecting the integrity of the court. And when a defendant repeatedly ignores orders, even a patient judge will reach their breaking point.
Probation to January 24th, 2024. You show up on January 24th and they give you a sentence. Relatively straightforward sentence. You were in custody at the time. And I laid out everything that you needed to do. That was in January. You really don't do anything on probation that I ordered you to do. So then you show up June 12th of this year on a violation of probation hearing. And at that time, and I think you were on Zoom, you were out. We told you the things that you were supposed to do or hadn't done and try to get corrected. And at that point, I kind of just sent a warning shot to you and told you, you got to do these things. And I ordered you and ordered only 10 days. And Ms. Polaris trying to work with you too. I mean, we didn't order you serve the full time. We said, here are the things you haven't done. You need to get them accomplished. So I ordered 10 days in jail, gave you a specific day to report to probation on June 24th, 2024. Did you go?
I was in warrant status. I don't think I could have.
Oh, you could have.
You're right, for sure.
And then ordered you to become compliant with all the previous terms that I ordered. So I gave you another shot from January to that June day. The 10 days, because you were on Zoom, I told you exactly what I would do. I said you're to report by 6 p.m. that day, or I was going to issue a bench warrant without bond. You must have thought I was kidding.
No, Your Honor. Not
Then why didn't you go?
I didn't make it by 6. I knew the deal could have been off the table. But I definitely was not thinking you was joking.
Why did you not turn yourself in then?
And I was
You want me to give you another chance,
please,
and you did nothing.
I could complete this probation. Promise.
What?
I can and will complete this probation, possibly, if possible.
You can't. You do what you want to do.
I'm gonna speak
When did you get picked up on this one?
about 20, if I'm not mistaken.
July 20th. Okay. So between June 12th, when I ordered you to report to the jail, and that day you got picked up, what were you doing to correct this?
I was trying to work, make sure I had some money, so if I had other bonds. But I do apologize, and I can't say this, Your Honor.
Here's my problem. You're apologizing because you got caught. You were, if those police had not come to your door that day, I still wouldn't be seeing you.
Yeah, I probably would have turned myself in still.
When?
That was all.
In the 45 days from the time that I ordered it to the time that you got picked up, at what point were you going to turn yourself in?
As soon as I had enough funds to take care of other cases that's holding me with no bonds and counties like tickets. And I was trying to be there for the mother of my child that's currently pregnant. I would have done my probation this whole time, but I had other warrants stopping me from doing my probation. I'm not going to say, yeah, I didn't. I'm not going to say I didn't turn myself in. It was other warrants, other cases that's stopping me from being best at what I can show y'all and doing my probation.
I've given you an opportunity to show me. I'm coming up on a year, and guess what? What have you done? Nothing. Nothing. And then you're gonna, and
I
I
tried.
try to give you at least a gentle nudge, and you still don't do anything. Nothing. You tell me one thing on this sentence that I gave you that you've done.
It was my first time.
Tell me one thing you did.
I checked in. I tried. It was hard. I mean, I did check in, do the non-report.
Why is it that you just can't say, Judge, I did nothing?
I did nothing.
Because I'm looking right at it. You did nothing.
You're right, Your Honor. You right.
Everything with you is an excuse.
No excuses as a man. That's what I was taught. So I don't try to make excuses, honestly.
You've made excuses since the time you first started talking. Everything that's come out of your mouth is an excuse. I sit here and I give you a chance to do it. We wait 6 months, correct something. Anybody that is on probation in my court, if, you know, and I feel bad sometimes for Miss Polera, but she doesn't mind doing it. If you're having problems, you'll walk in, you talk to her. But you wouldn't even do that. You thought this was a game. You thought when you looked me in the face on Zoom and I told you when to report that I was just kidding. Nothing that comes out of my mouth am I kidding. I told you to report. I told you when to be there. And I told you how long you'd be there. And I told you what I would do if you didn't report. And so you know there's a bench warrant out for you. Because at least you took me for real on that I was going to issue a bench warrant. So when the police show up, what do? You don't even say at that point, I got to deal with this. You take off running. Allegedly, I guess we'll say at this point. And where was that going to get you? Got you right here. And after all that, Mr. Cummings, you want me to believe anything that's coming out of your mouth that doesn't resemble an excuse.
I don't got no reason to be trying to have warrant statuses and
you have no reason for any of this. Everything that has happened that's bad in this case is no one's fault but yours. And the problem is, had you gotten to your attorneys, had you gone through and you were truly going through doing something, hey, they would have helped you out. There's no doubt, Ms. Perrine or Ms. Pate, they would have been all over my coordinator's email, trying to figure out something to do. Quite frankly, even if you had at that point gotten to Ms. Polera, she would have been trying to do something.
I didn't want to be disrespectful.
Too late. You disrespected everybody here. So don't even play that game with me that you don't want to be disrespectful. You intentionally were disrespectful. You intentionally thwarted my order. You intentionally then tried to hide and seclude yourself. You were disrespectful, allegedly, to the police when they showed up, told you you had a warrant, you take off. Every move you've made has been just coated with disrespect to everybody involved in the process.
I wasn't trying to be disrespectful, calling my probation officer and not coming in to take care of the business. And I didn't even talk to the police or anything. They didn't tell me anything.
Okay. You had a warrant, you knew it, you took off. And if I didn't have those two gentlemen behind you right now, you'd run off again.
Definitely.
Every time. Yes, that's what you do.
I can't run.
What?
I can't run from you.
You can't run?
I can't run. Never.
I know, because you kept running before. And that's why you're here right now. That's all that you've been doing. Doing nothing and running.
I haven't had the probation because I had warrants for other cases. I would be straight on track with probation to this day. It wasn't for the other warrants, Your Honor. I promise you.
So you're telling me you weren't doing probation because you had warrants? Yeah, why'd you have warrants?
That's the
Why'd you have warrants? Because you hadn't done what you were supposed to do before.
They wanted me to turn my all type of. Your Honor, if I didn't have other warrants, I'd be straight on track with probation. Why would Miss Polaire is a good lady? I know you don't try to be as hard as you do or want to be, but
oh, I don't. Mr. Cummings, I do not want to send you
y'all
to jail.
are not
Mr. Cummings, I do not want to send you to jail. I do not like sending people to jail. I try to bend over backwards to give people the opportunity. When you need a nudge, and I may have to do a little bit of time, I do a little bit of time, trying to at least get your attention, get you back on track. All of those things, every one of them, I've tried with you. And you've done nothing. I don't even have anything in this sentence I gave you the beginning of this year. I have nothing that I could point to say you did or tried to do something. I have nothing.
That's what's off paper.
I have nothing.
I'm sure if it was
you could have Mr. Cummings, understand this. Your promises are no good to me. Your promises are no good.
Can I say one thing? I wouldn't have this warrant for probation if I didn't have the other warrants. That's how my probation. And I wasn't communicating with y'all or doing what I was supposed to do or should I have been. But that's not me though. I've completed a probation before I could do and complete this.
You still got warrants.
Everything, this is what I had to take care of. If it ain't a ticket, this is the only things I had to take care of.
Your Honor, I think he's referencing the domestic violence case that he did have a warrant for. But he
still does have a warrant out of 35th.
And he does have that drug license suspended out.
You don't take care of business. I can't help you. I really can't. Anybody that walks through that door that tells me they want to do something, want to follow what we say and try to work hard to try to change things, I'll help them. I know there's no two ways about it. And my entire staff, my probation staff, my staff will help you do what you need to do. And I know your attorneys. If you had reached out to them, they would have helped you. You just didn't. You wanted to do it your way. And your way doesn't work. So now we're going to do it my way. And it's just going to be harsh.
Chance to show y'all I will take care of this. I promise you not see me again. If it ain't to be getting released off of probation early or anything.
I'm going to waive the remaining terms except the defendant.
In the end, Judge had no choice but to sentence Mr. Cummings to 365 days in jail, crediting him for time served, but holding him accountable for the rest. It's a hard but fair ruling, a reminder that second chances are earned, not handed out. The judge even left the door open for early release if he completes the in-jail rehabilitation program. That's justice with structure, not sympathy. If you found this case as revealing as we did, hit that like button, share your thoughts in the comments, and subscribe for more shocking courtroom breakdowns just like this. Only here on Lawful Verdicts, where every case tells a story about justice, choices, and consequences. Welcome back to the courtroom, folks. And buckle up, because today's hearing takes a wild turn. We've got not one, not two, but three defendants facing serious bond violations, each trying to convince the court they deserve one more chance. From failed alcohol tests to broken tethers, the excuses fly fast, but the judge isn't buying all of them. Watch closely, because this courtroom gets emotional, intense, and at one point deeply personal.
Address the violations now.
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Response from the people.
Your Honor, we have concerns about involved like including. I would note that it's not just one incident; it's on 2 different days, and that the report of the case when Mr. McFall was collected about the August 19th date, he admitted drinking, but then we have an August 24th date. So
And also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those 2 on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down, he also then blew and numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
And so, Your Honor, part of the reason that we find it concerning, believe that alcohol may get involved with this, and that as far as the felonious assault charge, the weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that Mr. McFall applies with bond conditions that he seems to have violated them multiple times when he was confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really a substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He's here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
Now notice how McFall's defense shifts gears, emphasizing his attempts to turn himself in and his involvement with church programs. It's a smart emotional appeal, Judges value responsibility and proactive behavior. But the problem? The violations keep stacking up. And when a judge hears about drinking connected to a police assault charge, especially with a wine bottle as a weapon, that changes everything. The stakes just skyrocketed.
No, no. Just at my church, I don't have proof for it though. And I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Okay. Well, it looks like he is working on that, Your Honor. He signed
He's
up.
working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked, defendants remanded. Your name?
Melissa Kalwinski.
All right. What are we doing on this case?
Your Honor, we're asking for an adjournment for negotiations and to review videos.
You've seen the bond violation report.
Yes, Your Honor, and we have discussed it and I'm ready to address it when the court is ready.
Yes, I'm ready to address it.
Ms. Kalwinski stated that she did drink, but it was only that one day. This was a one-day slip-up. She didn't take the test within 15 minutes because she fell back asleep. She takes mental health medications at night, which has been reported to CMH, which make her fall asleep. She wasn't avoiding calls. One of the numbers that she gave was her boyfriend's number, and he said that he didn't receive any calls. The other number no longer works. She did believe they have her current number, but that phone only worked on Wi-Fi, but she recently got it switched to a phone with a SIM card, so it now works all the time. This Saturday, the 30th, she returns to work at Dunkin' Donuts. On the 11th of September, she will start a part-time inventory job. She also receives her Vivitrol on the 11th. On September 22nd, she has an appointment for mental health addiction recovery and an evaluation with IHA Trinity Health. She has been going to AA and has proof. Her letters of recommendations from
How long has she been going to AA?
She has the proof. How long have you been going?
I've been going over a year. It's a sunshine group. But since I've been out of rehab, this is what I have.
When did you get out of rehab?
I got out on the 15th
Of what?
August.
And she does acknowledge that
Instead of drinking by the 19th.
that was one day after. And since then, she has been testing negative. She has letters of recommendations from Bear River Health and one from her boss. She volunteered in Hanover, Michigan at Rust and Dust and has a letter from there also. She realized she slipped, and for the first time, she wants this court to know she caught herself and immediately got back on track. And normally when she slips, she goes on a bender. Ms. Konowinski is asking for more time to test instead of twice a day so that she is more accountable to herself and to the court. We ask this court to recognize that she had no violations after that date and to give her another chance, especially since she has appointments set up for her mental health and for her addiction. She is also here today knowing that she could be remanded. She would also like to address this court.
Good morning, Your Honor. And first off, I want to thank you for back in December of evicting me from my ex's house. I'm glad that you did. I did not want it because that was a safe spot to drink. And since being evicted, things have changed. It's come into a lot in my life. I don't have to be in that household with him. And for that, I thank you very much. During the eviction, I was scared because I was giving up my way of drinking. And to this day, if I would have still been there with that man, I would probably be dead. So I thank you for giving me the eviction. And I do acknowledge and admit my part in this addiction and what I did. I'm not saying it was right, but I want to be fully honest with my recovery completely with sobriety because I don't have any more to give.
Response from the people.
This is an overview I heard with two priors, both in 2021. This was a hit and run crash where the defendant was then located driving a vehicle with heavy front-end damage. She was so intoxicated they couldn't even do the field sobriety test. Eventually, her blood test showed she was a 0.280.
This right here is the crossroads every courtroom faces: compassion versus public safety. The defense is pleading for trust, showing letters, treatment plans, and AA proof, while the judge weighs one terrifying fact. At 280, she was lucky she didn't kill someone. And when the judge says, I can't take the chance that she'll hop into a car again, that's not anger. It's fear for innocent lives. So tell me, where's the line between second chances and protecting the community?
I have no faith that she can be safe in the community right now. I'm extremely concerned that even with this Graham Heather, given the levels that we see in the sober lane testing, and I also know from the court, I'm sure the court's already seen it, it's towards the end of her testing window. So that leads me to have suspicion about what was it earlier in the day. I'm extremely concerned for public safety. Should she be released at all, I would ask that her bond be revoked and she be remanded. If the court is inclined to release her, I would absolutely request a scram tether. I don't think sober lane is going to be sufficient for public safety.
And Your Honor, I think she would be okay with that as she did ask for more times to test so that she could be more accountable to herself and to this court.
And Your Honor, I have to go back to that. I don't think more times to test is going to be an adequate solution here with somebody that's at a 0.28 crashes, runs from the scene and has 2 fires.
Let me clarify. I was saying that she would be okay with the scram tether.
He's currently in some type of program.
She starts her program on the 22nd.
IOP intensive outpatient.
IOP intensive outpatient.
When?
September 22nd. She starts testing.
Do I have that? Is it somewhere in writing?
I have it on that.
She emailed it to me. I can send it to the court.
Well, you can send it to the court along with some order. There's got to be some structure. If she's not going to be in an IOP, I can't take the chance that she's going to go on another one of these, hop into a vehicle, and this time take somebody out. I can't do that.
Well, Your Honor, she has been negative, and that was just the 1 day slip up.
Yeah, but that's all it's going to take.
I understand.
She's got, this is her third.
I don't have a vehicle.
Don't
have a car. And I'm going to church and I'm doing AA and I volunteered. And I know what it looks like, but I wish people could see why I drink. To see the abuse and to see everything I went through. Well, why the hell I was living in.
I get all of that. The problem is that what's going to happen outside of the alcohol, you could potentially end up killing yourself just from the alcohol. But then all it takes is one of these slip-ups and somebody else goes. Somebody who had nothing to do with any of that abuse, had nothing to do with anything. They're all of a sudden wrapped into your world and your tragedy that you've been suffering. I get it.
I understand that, but I haven't drove in over a year or 2 years. I'm willing to go with alcohol tether, and I'm fine with that, Your Honor.
And Your Honor, she now keeps in contact with me as a support system. She calls me weekly and we talk.
And I have like letters.
Got to put together something. I'll consider it next week in terms of programming or something like that she's involved in.
Okay.
But
I do have IOP set up. I do have it set up with Medicaid rides and everything. I've been really working hard since I've been out to get back on my feet.
Going to happen again. Defendant's bond is revoked during the probable cause conference, September 4th, 2025, 9 a.m.
Yeah. Okay, September 4th, Your Honor?
Yes.
Thank you, Your Honor.
Your Honor, today is the date and time set for probable cause conference. At this time, we're going to be asking for an adjournment to continue negotiations, as well as give my client some time to hopefully pay off some of the restitution in exchange for a better offer.
Before I set the date on an adjournment, she has a no bond warrant.
Yes, Your Honor. As to the violation, Your Honor, my client still has the tether on her leg. As to the explanation, Your Honor, she tells me she was riding her bike and the tether got caught in her bike and like with the pedal, so she kind of had to adjust it. She lives far away from community corrections, That's why she wasn't able to go in
I
and
have a
get it.
broken phone too. I had my number to the tether guy in my phone and I had no way to contact.
So the tether came off in a pedal. She
No,
has a
it's
broken
still
phone.
on. It just pulled it and it poked it like there's something poking
Did
through
you
it.
call community corrections at any point?
That's what I'm saying. I was able to, I didn't know who to call except for the tether officer, Mr. Levitt, but it was saved in my
Was
phone.
your tether
which
going
was
off?
broken. It was going off, but I was on my bike and I was kind of scared, so I wasn't sure where or what to do. I did call my mom right away. As soon as well, not call her, but I went to her work. I rode my bike to her work actually, and tried to use her phone, but I wasn't able to while she was using it for work.
So if you didn't know where to call, what were you gonna do with her phone?
I was gonna call the public defender, which I did. I was able to email someone that following Monday because it was on a Friday, but I did text Hannah Mackey from the public defender that night when I was able to use her phone, explaining that there was an issue and that I didn't have a way to contact. And then when I did finally get a hold of him, and left a message out until tomorrow, I think, but I was waiting for someone to contact.
Did you go to the community corrections?
I called them. I did when I finally was able to figure out who to call when I got the email.
When did you call them?
I called.
How many days after this alarm went
Well,
off?
it happened on Friday, and then I got the number to call the community corrections that following Monday. I called and left a message for Mr. Levitt. I think I left the message actually today.
Your Honor, I just want to say that this is a tether was put on because I believe for a previous failure to appear, and she is here today, Your Honor. So it shows that she does want to comply with the court order. She does want to be here. She does want to handle her case.
But she doesn't want to comply. Have you been to the community corrections at all?
No, I live in Jackson. I was lucky to get here today. I wasn't even sure what was going on. I don't have a vehicle, or a phone at the moment, so I was requesting things through email as well, or trying to. I'm still charging it as well. Like I'm not trying not to.
She's not
go
trying
through
to
with this.
she's not trying to abscond, Your Honor. She's not trying to disobey the court orders. It was just, it seems it was just an accident. And just due to her lack of efficient communication method, I think that's really where the problem lies.
I have an old tablet from 2015, I think, with Wi-Fi for communication right now.
And when I reached out to her and let her know that she would be required in person because she initially tried to attend via Zoom and put in a request via Zoom, she did her utmost to make it here, and she's here, Your Honor. So
yes, but I don't
have a right.
understand why she didn't.
she hasn't even secured a ride back yet today. So
Yeah.
she her transportation.
Well, why she didn't keep in contact more with community corrections?
I think it's due to
I mean,
her
this
lack
thing
of.
went off almost 10 days ago.
Well, I was
And
waiting.
we don't-
I'm sorry.
Go ahead.
I apologize. I was waiting for someone to get back a hold of me through my mother's phone or through email because I wasn't sure and I was still charging it. So I honestly just assumed everything was okay. I know that sounds stupid when I say that out loud, but I didn't know what else to do as far as contact. As soon as I found out the information this morning, I did everything I could to make sure to come. And left another message on Mr. Levitt's voicemail, who will not be in until tomorrow.
The second page and what they suspect this defendant was doing is really alarming to me.
I'm not sure what that means.
Your Honor, I think that is mostly just speculation at this
Oh,
point.
I don't-
She still has the tether on. She's still been charging it. She's still.
What is?
And I don't think there's a hot zone to this tether, Your Honor. I think it's just a GPS tracking tether to make sure she comes back from court, is what I understood. And she is here today. So the purpose of the tether is being fulfilled.
Any response from the people?
Your Honor, when the court released this defendant.
In the end, the judge revokes bond after seeing too many broken promises. Each case here, McFall, Konowinski, and the tether violation, shows the constant tension between hope and accountability. Some defendants truly want recovery. Others, the court fears, just want one more chance to fail. That's what makes these hearings so powerful. They're not just legal battles, they're human ones. If you found this case as intense as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns every week.